Hi everyone, my name is Muskaan and I'm interning here at Law Minds. In this video, let's try and understand the concept of dying declaration and let's look at how and when these are admissible in Indian courts under Indian laws. So when any party brings a case against another party, the initial burden of proof lies on the party who has brought the case. In civil and in criminal cases, the level of the burden of proof differs. In criminal cases specifically, you have to prove that the other party is guilty beyond all reasonable doubt. Now, how do we prove that? How do we know what evidence to bring to prove these things, right? So that stuff is covered under the Indian Evidence Act 1872. It talks about the different types of evidence that you can bring to court, and it talks about the evidentiary value of such evidences. And it is on the basis of this evidence that the court usually acquits or finds a person guilty. So, dying declaration is one such type of evidence that you can bring to a court of law. So, let's look at what the meaning of a dying declaration is, okay? Anytime a person makes a statement before they pass away that explains the cause of their death or the circumstances surrounding their death. Now, what does this mean? So, for one thing, the person has to pass away. If a person has made a statement before they're injured and then that person, survives the injury, obviously that means that there is no dying declaration that has been made, correct? Secondly, it cannot be any statement made by any person who dies, right? It has the statement has to relate to the cause of that particular person's death or the circumstances surrounding that death. And we'll see the interpretation of what this means in a few later slides. So the point of dying declaration is that it can be used as a sole basis for the conviction of the accused. So generally speaking, hearsay evidence cannot be used as a sole basis for conviction, right? You need corroboratory evidence. You need direct evidence. However, a dying declaration has been given such importance that it can be used in certain circumstances as a sole basis for conviction. However, there are several conditions that any statement must fulfill in order to, first of all, for it to be considered as a dying declaration, and secondly, in order for it to be used as a sole basis for conviction. So, as I've already mentioned, generally speaking, hearsay evidence has very low evidentiary value. It's not admissible in a court of law. This is specifically laid down as a fundamental principle under Section 60 of the Indian Evidence Act, where it states that oral evidence has to be given directly. So when we think about dying declaration, it's seen as an exception to this general rule. And why is it seen as an exception to the rule? That's because of this legal maxim. It's nemo moritorius presumptor mentire. What does that mean? It means that a person who is about to meet his maker will not lie. So what this essentially is trying to say is that psychologically speaking, any person who is on their deathbed, who is about to pass away, they have no reason to lie and it's very unlikely that they will be lying. Therefore, they are presumed to tell the truth. So now let's talk about where this falls under the Indian Evidence Act. Section 32 specifically deals with statements by persons who cannot be called as witnesses. So this generally means somebody who is dead, somebody who cannot be found, etc. So section 32 subsection 1 deals with when it relates to cause of death. So in this particular instance, the person who has made the statement is already dead, right? So when a statement is made by a person as to the cause of his death or as to the circumstances of the transaction which resulted in his death, in cases where the cause of that person's death comes into question, that is called a dying declaration, and such statements are, admissible in courts of law. So these statements are relevant even whether the person who made them was or was not at the time in which they were made under expectation of death. We'll see what this means in the next slide. But for now, just remember that since the person has already passed away, then obviously the person who made the statement, this dying declaration, or the declarant, he cannot be put under oath and he or she cannot be cross-examined, right? Because they're already dead. So although there are all these restrictions to the statement, it is still considered as admissible evidence. So there's this illustration given in the Bare Act under the same section 32(1). And the first illustration given is on dying declaration. So here they give an example of a person A murdered by B, where A dies in injuries received in the course of which she was assaulted by B. The question is whether A was killed by B under such circumstances that the suit would lie against B by A's widow. Now, say just before A died, A made certain statements about their death, okay, referring to the death or referring to what happened, what B did before they died. Then all of these statements made by A would be considered as relevant facts and they would be considered as dying declarations. Now, the previous in under the act, it also says that the person may not have known at the time that he was going to die. So this is can be explained by this case. It's a very famous case, Pakal Narayan Swamy versus Emperor. It's a 1935 Privy Council case. Okay, in this, the deceased had left his house to go to a certain place, and he told his wife that he was going to this guy's house and he was going there to demand that the guy return the money he had given him. A while after this, the guy never came back home and his body was found in a trunk, cut into pieces. So the question before the court, the Privy Council at the time, was whether such a statement, the statement made to his wife, would come within the purview of Section 32(1). So the Privy Council held that even though at the moment he wasn't sure he would die, but he had already mentioned the circumstances of the transaction which resulted in his death, right? What is a transaction? It's a series of acts, right? So we know that he left his house. We know that he left his house to go to a person who had not repaid his money, and then he was found missing. And then he was found dead. So in fact, this was what is meant by dying declaration. So the expression, any of the circumstances of the transaction which resulted in his death, is actually much wider in its interpretation than just using the term cause of his death. Okay, so now that we've understood what a dying declaration is, let's look at what the types of dying declaration is. Now, under Indian law specifically, there is no prescribed format for any such dying declaration. So this can either be given directly or indirectly. Now, directly or indirectly, it can be done either orally or through written means. So when we talk about orally, it could be through words, it could be through gestures. When we talk about through written, it could be, maybe the person has written a document and signed it. Maybe somebody else has recorded his words in writing and signed it. And the person giving the declaration, has signed it. So obviously there are many different ways of filing a dying declaration and there's no one prescribed form. The ideal form of a dying declaration is what is known as a question answer format. So generally speaking, when a magistrate records someone's dying declaration, or say a medical officer records someone's dying declaration, they try to record it through a question answer format in which they ask questions and the person, the victim, he answers those questions, and they try and use the exact words that the declarant has used in order to ensure the credibility of that dying declaration. However, obviously this is not always possible, so even other means of this are allowed in court as dying declarations. Alright, now let's look at what are the essential conditions of a dying declaration. So what are the conditions that have to be met in order for a statement to be considered as a dying declaration? First of all, he must be aware of his impending death. Now, in say UK laws, it is absolutely certain that the person has to be aware that he's going to die or he is dying. However, as we've just seen, sometimes it's not necessary, as in the case of Pakal Narayan Swamy. However, all of that depends on the facts and circumstances of the death. Generally speaking, since the legal maxim is that a person who is about to die will not lie, say someone has been injured very badly in a fight and they know that their injuries are going to lead to their death, then most likely they're going to tell the truth of what happened, right? So generally they should be aware of their impending death, but it may not always be necessary. Another thing, the statement that is made should be related to the cause or the circumstances surrounding the death. Again, we already discussed this. You can't talk about somebody else's death when you're giving a dying declaration. If person A has died and they give a statement regarding person B's death, then that will not be considered dying declaration. It has to be based on their own death or the circumstances related to the transaction surrounding their death. This may include a suicide. It may include homicide. So that is the second one. Now, the third one, it must be proved that the statement and the declarant are both honest and credible. So this means that the declarant must first of all be of sound mind when he was giving the declaration. So that's obviously, it cannot be that he was not of sound mind and he was imagining something, and that's the statement he has given. And this is also to ensure that the declarant is of sound mind to identify the perpetrators of the crime or to explain the cause of how they died. So they have to be honest, they have to be credible. Next, there cannot be any external influence. So this means that nobody can have tutored them, nobody can have prompted them, and nobody can have coerced them into giving such a statement. And it is the fifth and final point, the court has to check the authenticity of the statement. So this means that the court has to ensure that the statement is honest, it is credible, and that there has been no external evidence, right? So if, say, for example, it is proved by the other party, or it is not proved by the party giving that there are no suspicious circumstances surrounding the declaration, then the court may decide that the dying declaration is not credible, because the benefit of the doubt must still be given to the accused, right? The burden of proof is beyond all reasonable doubt. If even with the dying declaration there is some amount of doubt that it has been tampered with, then obviously it cannot be used as the authority or as the sole basis for the conviction. So these last 2 points, so there should be no external influence and that the court should check the authenticity of the statement, they've been added in the case of Malela Shamsundar versus State of Andhra Pradesh. Alright, and finally, let's talk about one more thing, which I'm sure a few of you must have questions about this. The proximity between the time of this giving the statement and the time of the death. So now, here's the thing. The Act has not made any mention of how proximate the time has to be. The Act has not said that the statement has to be immediately preceding the death, right? So obviously this is something that the court had to interpret. And this was brought up first in the case of Sharath versus State of Maharashtra. In this case, the court held that there cannot be any sort of straitjacket formula in order to determine how much proximity there has to be between the time of the declaration and the time of the actual death. So the court finally held that it all depends on the facts and circumstances of each case. Obviously, if there's too long a time between the two, it would probably not be admissible as dying declaration. But if they've been in the hospital for a while and they've made several statements one after the other, then maybe the first statement could be considered as a dying declaration. So this all depends on the facts and circumstances of each case. Now, a great way to figure out when and where a dying declaration is admissible is to figure out when it's not admissible. So let's look at these points now. So point number 1, if the dying declaration is about something other than the declarant's own death. We've already covered this. Obviously, the dying declaration, the statement must be made on the death of the person or on the reason, on the causes, on the circumstances surrounding that death. 2, when the declarant survives. Now, the whole point of a dying declaration is that the person who has made the statement is no longer available to be cross-examined in court or to be questioned in court or to give oath in court. So obviously, if the declarant survives, that there is no question of it being a dying declaration. Thirdly, if there is any doubts with the dying declaration, if there's any signs of inconsistency with other evidences, if there is any signs of coercion or falsehood, etc., then obviously in those circumstances, it would be suspicious and it would not be admissible as dying declaration. Finally, fourthly, if the statement is incomplete. Now, what does that mean? When we talk about incompleteness of a statement, Say a person who is on his deathbed is going to reveal, say, the culprit or the perpetrator, right? And he says part of a name and he stops. And now there could be several other people with that name. Now, nobody will have any idea as to what he was trying to say. So obviously, such an incomplete statement would be inadmissible, because then in that case, the prosecution could just name whoever they wanted and say this is what he was trying to say. But that's not going to work in a court of law. However, an incomplete statement may still be taken as admissible dying declaration if the intention of the person who made it was clear. So if the person finished taking the names of the culprits and was going to say something else but did not, but it was very clear that he has named these people as culprits or as the perpetrators of the crime, in that case, that part of the statement can still be considered as a dying declaration. Now, whether it requires any corroboration or not is up to the court to decide. All right, and finally, we come to this: no evidence of the credibility of the declarant. So when any person is bringing a dying declaration to court and saying that, this should be considered as evidence, you also have to show that the declarant, the person who made the statement, was of sound mind. It is up to you to prove that. So in the case of Amar Singh versus state of Madhya Pradesh, that was the first time this was pointed out by the court. If there is no evidence given that the person was in a fit state of mind, then the credibility of the declarant is in question, and in that case, it may not be admissible as evidence. Alright, so now let's recap. Basically, a dying declaration is considered a very important piece of legal evidence in any court proceedings in India. And it's a statement made by a person who has passed away, and the statement is about the cause or the transaction leading up to the person's death. It is not considered less than other evidences, but it is very much considered equal to other admissible evidences in a court of law if the dying declaration is admissible in a court of law. Like I said, ideally the best form of a dying declaration would be by a competent magistrate or a medical personnel in a question and answer format using the exact words of the declarant. Obviously, in this case, they have to ensure that there is no prompting being done. You cannot ask leading questions that will make it seem like you want a particular kind of answer. They have to be very open-ended questions, and they can only use the exact words that the defendant has used in the answer of the defendant, right? So in the end, the courts have to make sure that there are no suspicious circumstances that is on the court. If any other party, if the opposing party brings up some sort of suspicious circumstance, then obviously it will not be the sole basis for evidence. And the declarant must be of sound mind. There should be no indication of coercion, force, imagination, etc., etc. So again, it always depends on the facts and circumstances of each case, and it will differ on a case-to-case basis. So that's the end of this video. I hope you all have somewhat understood what is the meaning of dying declaration and how it is admissible in Indian courts of law. So thank you all for listening, and please hit that like button and the subscribe button.